Hello, everybody, and welcome to the latest in the series of occupational health and employment law webinars delivered by ourselves at Simply People. Thanks so much for joining us tonight. I normally fill for a couple of minutes just to let people have a chance to join the session and log in and things like that. And then I normally leave it to about 1 minute past, and then I'll start my piece, which takes about 30 seconds, and then I'll hand over to Jodie. So thanks everybody for joining us today and tonight. It is really appreciated, and hopefully you are finding value in these sessions. If there's any other topics that you'd like us to talk about, or that you feel would be a really good area of interest for yourselves, then please do let me know. We're constantly looking for new ideas for webinars, and our range of speakers are, you can tell from Jodie, are absolutely fantastic. So we want to ensure we continue to deliver these high quality events for everybody in the community. So there we go, it's 1 minute past, so I will get started. So welcome everybody, and thank you for joining us for today's webinar. For those of you that don't know these dulcet tones, my name is Danny Clark and I am the founder of Simply People. Simply People are connecting a community to improve the physical, mental health and wellbeing of employees in the workplace. We also support clients and providers to find each other, and clients to ensure that they get right practice the first time as much as possible through a concierge service that is available through our website that is completely free of charge. Today we are presenting disability and reasonable adjustments, and the session will be delivered by Jodie Hill, who is the founder of Thrive Law. Just a little housekeeping before we get started. If you have any questions during the presentation, please type them into the question box in your GoToWebinar control panel. I'll bring them up during the presentation, and we will also have time for questions at the end. Just to let people know, this is an interactive session, so you will be asked for your answers to a couple of questions through the slides. I won't say any more than that to keep your interest, but please make sure that you are in a position whereby you can participate to get the most benefit from this session. Without further ado, we'll turn the time over to Jodie. Our presenter today trained as a barrister, cross-qualified as a solicitor, and founded Thrive Law in 2018. She is the founder and managing director of the award-winning organisation. They are headquartered in Leeds City Centre, and Jodie has specialised in employment law throughout her career and has a keen understanding of this complex legal sector, together with all HR-related issues. Jodie, I'll hand over to yourself. Thanks.
Awesome, thank you so much. So yeah, as Danny said, one of the things that I specialise in is employment law, but specifically disability discrimination. So this is right up my street. So happy to take any questions. Just a bit of a caveat. Obviously, I can give a kind of suggested answers and things like that, but I can't give specific advice because I'd need to know a lot more information than just what you type in the box. But I can guide you in the right direction, and hopefully the purpose of today is to really expand your knowledge around what is a disability, what are adjustments, what's reasonable, what's not. And I'm going to go through some case studies. I've got some guidance and some YouTube videos linked within the slides. So don't worry about writing everything down. There's loads and loads on the slides. So I wanted to basically put as much in there as possible with relevant links to guidance and other helpful things that I think that would help you guys if you're actually dealing with this in the workplace. So yeah, don't worry about writing everything down. I know a few people emailed me before when I've done a session. They say, well, I was writing everything down and I missed something. So I've gone a bit more comprehensive on the slides, and then actually you can just have copies of those. So I'll send them to Danny afterwards. That's me. We, as Danny said, we're based in Leeds, but we support businesses across the whole of the UK with everything from tribunals to HR to reasonable adjustments to managing long-term sickness absence, you name it, we support businesses with it. So as I said before, ask your questions and let's get started. So the first thing that, I mean, actually, apologies to anyone who came to the last discussion that I had on disability discrimination, but it is relevant to understand who's protected and what a disability is before we make adjustments. So I'm going to spend the first part of this talk just explaining who's protected and really just understanding what a disability is under the Equality Act. It's quite important before you actually consider adjustments. So the first thing is that employees and job applicants are protected. So there's no prescribed period of time. Like with an unfair dismissal claim, you have to be employed for more than 2 years. There isn't that prescribed amount of time in terms of eligibility. So anyone who's employed or anyone who's a job applicant should not be discriminated against. And that applies for reasonable adjustments because you might need to make them at an interview. workers and self-employed people can be covered. The law's quite vague in this area. The definition of employee can be stretched to workers and self-employed in some circumstances. But people who are genuinely self-employed, so a consultant in an organisation, for example, who might work for lots of different businesses and invoice every month, they're unlikely to be covered. So it's quite a difficult test when we talk about status. But essentially, the key people who are covered are your employees, your workers, your applicants. If someone looks like they're self-employed, they might not be covered. But what I would suggest is, because it's so fact specific and such a complex legal test when it comes to defining status under this particular act, I would take advice if you're not sure whether that person is eligible. Volunteers and interns is an interesting one, and the reason I put that on there is there's a recent case law to say that volunteers and interns, where they have a contract, are covered. And that's interesting, I think, for a lot of organisations, because they probably don't expect that. So again, if you're thinking about processes internally, how do you onboard volunteers and interns? Do you onboard them the same way in terms of exploring whether they need adjustments? They need to be categorised in the same way, but it's only where they've got a contract. So hopefully that gives you a bit of a heads up that it actually covers quite a lot of people, and the definition is quite wide. But let's talk about what actually is a disability. You can see the heading there is hyperlinked. What I've done there is there's a really helpful guide set out actually by the government on one of the equality websites, and it essentially goes through in so much detail with really great case studies what the definition of disability is. And the idea behind it is breaking down section 6 into, and I think it's about 60 pages. So anyone that's bored in lockdown, read it. But genuinely, if you have any questions or concerns about whether someone might meet the definition, you can look at that, and it's really, really helpful. So as I say, it's linked in there, and it's free to find online, but I just thought it'd be easier for you guys to find. So the actual definition of disability is contained in section 6, and I've set it out on the slides, but essentially the crux of it is you don't need a diagnosis of a condition, you just have to show that it meets this definition. So it's not the same definition as a blue badge disabled person in a medical sense. This is a legal definition, so that's the first thing to consider. The second thing is it's a physical or mental impairment, so you have to identify whether it's physical or mental, and then you look at what the impact is of that impairment on the individual's ability to carry out daily activities. So that impairment has to be something more than minor or trivial when it comes to the impact. So I'll come on to some examples of that, but essentially it's not just that they feel uncomfortable or they don't like to do something. It actually has a substantial impact, and a long-term impact as well. So when we're talking about long-term, we want to be thinking about is it likely to last more than 12 months? So for example, if someone's recently been diagnosed with depression, whilst right now obviously they've only just been diagnosed, that may still be a mental impairment that has a substantial and adverse negative effect. And it probably is likely to be long term. So it does depend. What is long term or substantial for one person may not be for another. So you mustn't assume that somebody doesn't meet a definition because you had an ex-employee and Occ Health said they didn't meet it. It's very fact specific. So you have to explore with every individual what their substantial and long-term negative effect is on their ability to do their normal day-to-day activities. So it's very much a conversation that needs to be had. And even if they have a diagnosed condition, you still have to explore this, because it doesn't always mean they meet the definition. I've represented many people in tribunal. I represent employers and employees. And I've seen some people who've actually been suicidal, and the tribunal said that it doesn't meet the definition. But then other people who had quite a minor anxiety but long term, and because they managed to show the substantial and long-term effect, they were able to actually meet the definition. So it really does vary in the tribunal. But from a practical perspective, I always think if somebody has a condition or an impairment or something that's stopping them from doing their job to the best of their ability, why not make an adjustment? So this is very academic in talking about the definition, but often employers want to know that before they spend money on an adjustment or go down a certain process. So it is important to understand, but I think in practical terms, if you can support someone in the workplace and you're not really sure if they meet the definition, I would err on the side of caution and actually just make the adjustments if they're reasonable, which we'll come on to. If someone has cancer, HIV or MS, there's no requirement for you to go through that test that I just talked about, looking at the physical or mental impairment and the effects. They're automatically disabilities from day one. So they're the three that you don't need to do anything with. In terms of knowledge though, so there's one thing somebody having a disability, there's another thing whether the employer know. First of all, whether they know of the impairment, but secondly, do they know of the impact it has on their ability to do their job or anything in their life in terms of their normal day-to-day activities. And that's what's really important, is understanding what exactly you as an organisation do know. And if you don't know enough, then you need to get more information. Now, the reason I bring up knowledge here is that often someone will say, I don't know, they'll mention in passing that they've got a condition, but they never really talk about the effect, or in fact, there's no obvious signs that it's impacting on their ability to do their job. Now, even though the employer might know about it, there's not necessarily a burden at that point to make any on the employer to make any adjustments. So it's at the point where you know there's an impact where the duty arises. But obviously, if you know of a condition, it's at that point, from a practical perspective, you should start exploring whether or not it does have an impact, because ordinarily employees aren't going to tell you off the bat because they're more concerned about it impacting on their performance. So whilst there's no legal obligation on you to explore that from the outset, it's certainly the most practical way to approach it. And actually, you can then foresee if someone needs adjustments and put them in earlier. There are lots of other types of discrimination, and I'm not going to talk about any of those today, but we did a session on those a few weeks ago, so you'll be able to have a look at those. But essentially, making adjustments is a requirement under the Equality Act, and a failure to do that is a type of discrimination. So from the date that the employer fails to make a reasonable adjustment, the employee has 3 months to bring a claim in the tribunal. Now, there are other types of discrimination which I've listed there at the bottom of the slide. You've got direct, indirect, harassment, victimisation and arising from discrimination. All of those are applicable to disability as well, but we're just focusing today on reasonable adjustments. So first step is understanding who's covered. So are they an employee, an applicant, or do they fall into any of the other categories that potentially could be covered? Do they meet the definition of disability? And then we move on to, bear with me, just double checking that nothing falls into the exclusions. So exclusions are essentially all of these things. I'm not going to read them out to you. You guys can all read while I'm talking. But essentially, if the reason that they're asking for an adjustment is linked to any of these things, they're actually excluded from the definition, so you don't need to make an adjustment. It's quite rare that these come up in practice. I don't know, exhibitionism comes up often linked to mental ill health, but if it's linked to that, there's no obligation to make an adjustment. It's only if for example, their mental condition has another reason that they need an adjustment. So generally, like I say, these very rarely come up, but it's worth knowing that these are the exclusions from that definition. Oh, just bear with me, my mouse has died. There we go. So what are reasonable adjustments? Well, the purpose of them is to really put the disabled person back in the position they would have been if they didn't have a disability. So what we always say is that the idea behind the adjustments is to really either remove or to at least minimise any disadvantage that they experience by virtue of that disability in the workplace. So the most obvious example of that is when, you know, a disabled person in a wheelchair needs to get up some stairs, you'd put a ramp or a lift in. So you can visualize that, and we're going to talk in a little bit more detail about other conditions that are less obvious, but you can visualize that, can't you? You can see what the purpose is, and obviously the aim is to then allow them to function as though they didn't have that disability, or at least with as minimal impact on their ability to do their job. And some adjustments don't completely take away the disadvantage, and they don't need to. They just have to alleviate the disadvantage faced by that disabled person. And obviously that's going to change for different conditions, different workplaces, and it's also going to be different for individuals themselves, because it's their impact that's different depending on their condition, and obviously how it affects them at work may be different to someone who's got the same condition. So it's very, very personal. But if you have that purpose and the aim in mind, it's really helpful then to assess it. It's not to make, you know, not to make them completely perfect in the workplace, but it's just to really put them on an equal footing. So the relevant law, I've set it out here in full. I'm not going to read through it all, but it's just helpful. I know in the last sessions people did message me asking where the relevant legislation was. So in terms of, we're always talking about the Equality Act, by the way, for discrimination, but it's section 20 where the actual duty arises. And the duty arises in 3 different ways. So you've got, and I'm going to talk about the provision, criteria and practice first. But essentially the 3 different types are, one is a physical, so if someone needs a physical aid, you've got an auxiliary aid, and then you've got a visual. Now, where an employer has a provision, criterion or practice, so that is like a policy in place, or I don't know, it might be the requirement to come into the office but there's no ramp, or it might be a requirement to work from 9 till 5. So there are certain requirements. Might not be called a provision in the workplace, but that's where they fit into the definition. So it might be a policy, a requirement. It doesn't have to be something written. It might just be a rule or just the way things are in the workplace. And that those provisions or criterions or practices within the workplace generally would apply equally to everybody, but place the disabled person at a substantial disadvantage because of their disability. And so the purpose then of the adjustment is to alleviate that disadvantage and give them an equal playing field, or at least alleviate it to a degree. So with reasonable adjustments, it's not just about saying I need this help at work. What the individual does if they bring a claim is they actually have to identify what the provision, criterion or practice was that placed them at a disadvantage, and they also have to identify what that substantial disadvantage is. So from an employer's perspective, it's really important for you to understand, okay, so if someone needs help, why do they need help, and actually, you know, what is it that you're adjusting? And that might sound a bit backwards, but so many employers will actually skip that part and they don't look at what the disadvantage is or how it will help them. So it's really important to explore what is the provisional criterion or practice that you're adjusting, and how are you alleviating the disadvantage with the adjustment. So there are various ways in which you can do that, and I'll come on to those later, but you know, that it's not a simple question of I just need this in the workplace. It's actually looking at, is it an auxiliary aid that they need because it'll actually help them hear better, or is it a physical ramp because they'll actually have access to the office? You know, there are so many different ways that can improve the experience for people in the workplace, but ultimately the aim is to remove that substantial, or at least alleviate that substantial disadvantage for disabled people. So remember the provision, criterion or practice, and also remember to identify what that substantial disadvantage is and identify how that adjustment will be alleviating that disadvantage for that disabled person. And when you're doing this, it's comparing it to a non-disabled person, to basically take reasonable steps to put them in that position that they would have been if they didn't have the disability. So I'm going to go through some examples, and then I've got a couple of case studies where we've got actual facts around, you know, this is what's happened in this case, and then actually I've got a couple. I think I said to Danny, I've got 2 cases where I'm going to ask you what you think, and then we'll do a poll and we can decide whether or not we think it was a reasonable adjustment or not. So to help you with that, I'm going to go through some examples of reasonable adjustments that I've seen people put in place. But again, what I would caveat this with is it depends on what the provision, criteria or practice is, what the disadvantage is, what the disability is, and how it alleviates it. You know, just adjusting someone's start or finish times might not be an adjustment to someone else. So whilst these are examples of ones that have worked, it is very fact specific. So yeah, so we've got adjusting start and finish times. I think that comes in specifically for people who have mental health problems, struggle sleeping, some people with physical problems with pain management. Again, that's come up quite a lot, similarly for home working. Providing a quiet space to work or a designated space is something that has come up with someone who has OCD, don't necessarily want to hot desk. Providing a quiet space to work. I mean, I have anxiety and ADHD. I need to be in a quiet space, otherwise I'm really distracted. But lots of people with mental health conditions will identify that as a reasonable adjustment because it allows them to concentrate, so it alleviates that disadvantage. Increasing support and training regarding certain tasks. Now that's quite a wide one, but it's really there to make you think about, is there, is the policy or procedure in place? Is there something that you can do in order to help someone achieve that? Or do you need to adjust the policy, or do they need training or support? So it's really just looking at what is it about that policy or procedure or particular task that they can't do, and then assessing whether or not there's an adjustment that you can put in place. So one of the adjustments that's really common for disabilities where you've got like long-term sickness absence is actually looking at whether or not you can discount that policy. So often a policy relating to capability would say, at this point, I don't know how many days sickness, you get a trigger point and it goes to the next level of sickness management, or it triggers a capability process. So those trigger points are often set by the number of days in which someone is off for. If you have a policy like that, it may be worth considering discounting any sick days that are related to a disability from that as part of the process before you decide to dismiss. So this is making adjustments prior to going down a dismissal route, but essentially that could be, because it's not necessarily about them physically doing their job there and then, it's about alleviating that disadvantage, which is potentially a dismissal. So again, you can see how it's actually looking at the processes. You're identifying your policy, your procedure, or your criteria within the workplace, and then seeing how you can adjust that to alleviate the disadvantage. So that's quite a common one that we find employers get caught on. If the employee is then dismissed and there are no adjustments made to the policy, what we often find is it also results in a claim for disability discrimination, where it's arising from the sickness. So you end up with two claims for discrimination against the employer, even though they've probably done it fairly under the capability process. So it's just worth considering making adjustments, even if you're in a different process, the disability stuff still runs alongside it. Changing the way we communicate to disabled individuals in the workplace is really important, especially if someone is neurodiverse. They may need something to be put in writing because they struggle with social cues or verbal communication, or equally someone with dyslexia may need to have a conversation with somebody because they struggle with reading and writing. So it's just understanding whether or not the disability does affect their communication and whether you need to communicate in a different way. Removing things like bright lights, again, neurodiverse individuals can often find that really difficult. I know people that suffer with migraines, that can be a disability because it does have a substantial and adverse effect if it's a consistent occurrence. So things like that, again, it's not necessarily putting something in place, it might be removing or allowing them to adjust. So I know a lot of workplaces now have the ability to adjust the temperature, the lighting, the desks, everything within the workplace to suit the needs of each individual. When I talked about before the, having a quiet space, it could be that you don't have a quiet space. So you could think about things like putting screens up or creating areas within it, even if it's in an open plan room, where you can reduce that noise or distraction. You could also consider things like headphones or specific, they're like barriers that you can put between desks. So it's not necessarily that you have to go and buy a new office. It's about looking at how can you adapt what you've already got to just reduce some of the disadvantage. And then obviously I've referred to the fact that we've got the physical stuff. I think the physical ones are much easier, getting someone a chair that supports their back or providing a ramp. Those I think are really obvious. What employers tend to struggle with is the nuances of invisible disabilities or mental health conditions that they are less clear in terms of how they can support people. So I've given lots of examples. If anyone else has got examples, please pop them in the chat and we can have a chat about those at the end. And obviously, if you've got any questions about reasonable adjustments as we go through, don't forget to ask those. So I'm going to do a couple of case studies now to give you a bit of context. So we've got a client that suffers from, I'll call them a client, they'll probably be your staff, suffers from ADHD and anxiety. You know about it, they've suffered for a long time, but the policy, so we've got your provision, your criteria of practice is in the company, you have to set your own targets and you have to work within those. Now, the employee asks for a reasonable adjustment and they say, actually, we'd like to have those targets in writing and agreed in advance. The reason for that is because anxiety, they don't like the uncertainty, the ADHD, they get too distracted, and the combination of those two things means that they don't get anything done and they're just procrastinating about what they need to do. So part of that is about communication, but it's also about adjusting the policy in which obviously applies equally to everybody, but places this individual at a substantial disadvantage because of their disability, or disabilities in this case. So they could both be a disability individually or collectively. So hopefully that makes sense, but please ask questions if I'm going too fast. Other case study, we've got an individual suffering from BDP, can't speak today, BPD, that's a alliteration there. The client is particularly unwell in this one. So this actually comes from one of my clients, so this has actually happened to someone, and they went off on long-term sick, and what happened was they were under the support of a crisis team and mental health team, and effectively asked their employer, they said, I can't communicate with anybody right now, I'm in crisis. And when I say crisis, suicidal and being watched on a daily basis. They asked their employer to communicate through their mental health team, because that alleviated the disadvantage and potentially stopped any triggers. Couldn't communicate with anybody outside his family. Unfortunately, the manager refused to do that and kept contacting the client directly and actually triggered an attempted suicide. So in that situation, that for me, and we're actually still ongoing through this tribunal process, but that was clearly, this person is clearly disabled. They clearly needed some support, but they were on long-term sick, so it's not support in the workplace, but it was an adjustment to a policy in place, which was, well, our policy is to contact you every week directly, and the manager in that situation should have made a reasonable adjustment to their process to alleviate that disadvantage and communicate it through the mental health team. So what we find is sometimes it's not that people do things because they don't want to make the adjustment. Sometimes it's lack of understanding, or actually they're being told, well, my policy says I have to do this, and it's the policy that needs adjusting. So that's really the mindset that I want people to get to go away with from today. So what's reasonable? Good question. The case law is really, really vague on this, and there's an awful lot of conflicting cases, but essentially, from a business perspective, it's very fact specific. So what's reasonable to one business is not going to be to another. What's reasonable for one organisation with a condition is going to be different to a different condition and a different employee. So what I would say is just make sure that you objectively justify if you're going to refuse. And what I mean by that is why can't you do it? Balance why you can't do that in the organisation with the impact it has on the individual by not having it. And then balance whether or not you think it's still objectively justified. And actually, if you could put it in place, and it might cost a little bit, but actually you'll know that they'll be more productive and actually you alleviate that disadvantage, then I would always consider putting it in place if you can. You can't refuse it just because you can't afford it. It can't be the only reason. There has to be another business reason. So if you just say, oh, it's too expensive. Now, this is a bit different if they ask for, their own car or something, I don't know, and you can't afford to buy them a car. But generally saying, oh, we can't afford, a specific chair or things like that, it's not enough on its own. You need to have an objective justification more than just cost. Now, the tribunals in these types of cases will always consider the size and resources of any organisation, but they'll also consider what steps they took prior to making that refusal. So whether or not they explored if there were any other adjustments that they could have made instead, and whether or not they were actually able to objectively justify, or they just said no. So what a lot of organisations I've found in practice when I'm representing individuals, obviously none of my clients because they take advice and they do it properly, but when I've represented individuals, the reason they're going to tribunal is because their employer hasn't even thought about this. They've asked for an adjustment and their employer either didn't know about their obligations, or take a pretty blanket view. A lot of employers will say, oh, well, that's not what we do, our policy is this. Don't really have the understanding of their obligations to adjust that for disability. So it's just worth keeping a paper trail of all of that. And if you are going to refuse them, have a meeting with the individual and explain it to them in person. I think it's come so much better from a manager if they actually explain why. Just simply refusing it can damage the mutual trust and confidence between the parties, and it kind of feels like to the individual that you don't care, when actually if there's a genuine business reason why you can't do it, then you need to tell them that. And then I would follow it up in writing to make sure it's really clear that you've had this conversation. These are the objective business reasons why we can't do it. Or if there are some that you can, explain why you could do those. So you've got a paper trail if and when anything comes up in the future, which hopefully it wouldn't, but you just never know with these things. And especially if later down the line, an employee tries to say, oh, you didn't make adjustments. But you did, but you only made some of them. At least you've got a paper trail of what was agreed. With adjustments as well, I'd always say if you are making them, keep them under review. There's no obligation for you to have them indefinitely. So again, it's just a bit of an internal admin thing, but once someone has an adjustment, it's definitely worth keeping them under review, especially if their conditions fluctuated or they've actually recovered. Some people may be disabled for a period of time and then they may not need those adjustments anymore. So again, just worth something to keep in mind. Okay, this is where the engagement comes in. So we're going to do a little poll. So I'll read this out whilst we get the poll up. But essentially, we have so we've got a physical impairment here. So we've got someone who has severe back problems and required to travel to client locations. That's the job. The salary is calculated through chargeable days of the year. Occupational Health have got involved on this one and suggested that she needs to travel less because of the back problem. The employer said that it would make it impossible for her to do that role because there weren't enough clients in the location where she lives, and the role was pretty much on the road. So they've actually refused this reasonable adjustment. What do you think? Do you think it was reasonable do we think it's a reasonable adjustment that she's asked for, or do we think it's not, or are we not sure? Let's see what everybody thinks. Let you guys have a minute, have a think. Can you still read that when the poll's up? Do you need me to read it out again? I'm just trying to think. Probably can. It's really weird because I'm talking to myself. But I'll let you complete the poll first. And then
it does say, would this be a reasonable adjustment? So it is the poll.
Yeah, cool.
So I'm giving it the minute, like we said, and then I'll close the poll after the minute.
Yeah, can you see if people are filling it in? Can you tell anyone?
They are.
Yeah,
we can see the answers as well.
Brilliant. Okay.
Which is really good, really insightful. Okay, that's it closed now.
Okay, what do we think? Do you want to share the answer?
So yes, the answers are 48% said yes, 13% said no, and 39% said not sure.
It's hard, isn't it? So I'm going to give you the answer. Some of you were right. That doesn't really help.
Really helpful.
I know, yeah. So this is actually brought out from an actual case. So if I break it down, so the answer was, first of all, it wasn't a reasonable adjustment in this circumstance. So what they've said is, whilst there was a PCP, so you've got your provision, your criterion or practice, which is to require the individual to travel around, and actually, permitting her to work from home was the adjustment. But what they're saying is, well, it wasn't it wasn't a reasonable adjustment because her role was a travelling role. So it would have been different, I think, if her role, you know, could have been done in a different way, but because her role was a field sales role and she had to be on the road, it was almost impossible for her to do it from home because of the nature of the role. So do you see why it's really fact specific and why it's not reasonable in that circumstance? Because there wasn't a role that she could do from home. So hopefully that makes sense. I've got just one more, don't worry, no more tests after this. But I do think it's helpful to do these because you see how everyone was split then. That's really common, and actually that's why it's really helpful to bounce off someone if you're in that position and you're not sure, because what you don't want to be doing is explaining this to a judge, and whilst that doesn't happen in many cases, you know, you've even got the impact that it might have on the individual, and they might end up leaving if you can't make an adjustment for them. So you might have other claims that arise as well, which I'll talk about a bit later. But essentially, it is it's a really difficult position to be placed in as an employer, and there isn't always a right answer. So balancing that reasonableness, and actually, you know, if you ended up in a position where you were in a tribunal, then if you've gone through those steps I talked about before and been able to objectively justify it and actually, you know, set out clearly why it's not possible for the organisation, then you're in a much better position to defend anything like this if it ever did occur. So it's about minimising the risk for the business, but also supporting individuals in the way that we can. Oh, just bear with me, I've just gone backwards. Oh no, I've gone forwards. There we go. So we've got another poll. So I'll read it out and then we can put the poll up. So the employees asked to move desks. Said that she couldn't do this due to alcoholism, depression, anxiety, which was actually triggered by previous desk moves. She went off sick, and the senior manager said he had no interest in her issues regarding the previous moves, and requested to return her to a previous desk, which was also supported by occupational health. What do you think? Do we think it's a reasonable adjustment to ask her to allow her to move desks? Look.
I'll keep this one open for a minute as well, Jodie.
Yeah, that's fine. Sorry, the reasonable adjustment is to allow her to stay at her desk, not to the other way around, not to move desks. It's double negative. So yeah, do you think it's reasonable for her to allow her to stay where she wanted to stay and not move again? And I suppose as well here, what's relevant is it's actually suggested by occupational health, and I think it is important. You don't have to have occupational health involved, but I do think it's really helpful to get them involved, because they're an independent party who can actually talk to the individual objectively about their workplace and what adjustments that they could put in place. Now, what occupational health suggests doesn't always have to be what you put in place, but it's a really good starting point. Okay, what were the results?
So 79% of people said yes, 6% of people said no, and 15% said not sure.
Cool. Okay. Oh God, the suspense. My mouse is not working. Come on. Oh, this is what the tribunal said. Here we go. So the tribunal upheld that the employee required the security of an established routine in the workplace, that any change posed a threat which unsettled her, and that was obviously because of her mental ill health, which amounted to a mental impairment, and she'd suffered obviously to meet the definition for more than 12 months. So they've actually said that it was a failure to make reasonable adjustments. So it was a reasonable adjustment to ask for that. So most people got that, I think. What did you say? 70? What you said, Danny? What were the results?
79% said yes, 6% said no, and 15% said not sure.
Yeah, so that's good. getting better, guys. I love this. It means we're learning. So no, that's really good. And actually, it is helpful, like I said before, to get occupational health involved if you're really not sure. A combination. One thing I'd say is get a combination of a legal and a medical opinion, because the legal opinion is looking at making sure you don't breach the Equality Act. The medical side of it is actually what would actually help them in their role, and occupational health are the best place to help rather than a GP. GPs can help, but essentially all the GP is going to do is repeat what the employee says, whereas occupational health can look at, obviously Danny can talk to you more about that, but they can do a lot more in terms of actually exploring those adjustments, and they'll have a lot more experience in it. So yeah, so hopefully that was helpful. A couple of practical tips from me, which I've probably already touched on, but I'm gonna hammer the points home a little bit more. Really do listen, and please don't make assumptions. Just because Bob's got anxiety and Susan's got anxiety doesn't mean that they manifest in the same way, and one might be disabled, the other one might not. One might need adjustments, the other one might not. So you really have to move away from making any assumptions when having discussions as well. You know, I'd always say ask the employee what they think would help them, and put it onto them. If the employee doesn't know and you're not sure, that's when you then need to get other people involved. And it might be that they actually don't know. You know, they're just saying, you know, I'm really struggling with this and this is why, but I don't know what the solution is. And really the employer needs to work with the employee to come to a solution, rather than waiting for the solution to appear. And that can often happen where the employer will say, oh, actually the employee didn't suggest any adjustments, therefore we didn't make any. Well, that's not how the law works. If you know they're disabled, you have a duty to make adjustments. It's not just a duty to make the adjustments that they asked for. So again, you know, that's why you really need to listen to what they say, and actually if you can involve medical practitioners or occupational health to get you to that point, or take legal advice if you're not sure what would be reasonable. Once you get to that point, then that's really the place that you need to be. As I said before, please keep paper trails, keep a written record of everything about disabilities, any conversations around reasonable adjustments, what was agreed, how long it was agreed for, and obviously if you've got a review in place, make sure that's properly diarised and everything. And make sure you comply with your own policies and processes as well. There's a lot to consider, I think, for employers, especially when it comes to the Equality Act. You obviously have your own internal processes, your own capability processes, anti-discrimination adjustments, all of that side of it. So make sure first and foremost you're always complying with your own processes, but then always have regard for the fact that the Equality Act overrides or that's in the statute. So just making sure that everything's aligned really, and actually that those policies and processes are up to date and in line with it. Now, I know that the Equality Act's been out for 10 years, but you wouldn't believe the amount of companies that still have the DDA, which is the Disability Discrimination Act, in their policies, which is wrong. So again, just things like that are really helpful. If you have a clear process in writing of how to make requests for adjustments, that can really assist people in understanding where the company sit, what they need to do, how they need to do it. If you don't have one of those in place, it's certainly something worth considering as part of your internal processes or in your handbook. I talked before about the risks of getting it wrong. We've just looked at 2 claims. They're both of those, both of the little polls that we did, they were both real cases. And I've put the name of those cases if anyone wants to read a bit more about them. But the judgments are always really helpful. Obviously mindful that you guys aren't lawyers and I am, so I obviously find the judgments really interesting. But equally, what you find is the judge explains why they don't think it's reasonable in quite a lot of detail, and I think sometimes that can be really helpful for a bit of context. I'm not suggesting you all go away and read loads of cases, but you know, if you said the different answer to what the answer was, it might be helpful for your understanding if you want to read those. Now, the risks are effectively claims in the tribunal. I think you've also got the damage to reputation if somebody you know, talks publicly about the fact that the employer refused to make adjustments. But you know, the main risk really for most organisations is the cost of a disability discrimination claim. They are uncapped, anyone can make them, despite, even if they've only been employed for 1 day or even in a job application, they can still make them. Obviously, the value of the claim is going to go up the longer that they've worked there, and if it also resulted in a dismissal. But essentially, the individual can claim injury to feelings, and it's pretty wide. It's uncapped. But the average claim is probably about £12,000, something like that. But then you get it can increase depending on the impact to the individual. So if the failure to make adjustment, ended up in them almost taking their own life, you could be looking into the 10s, 30s, 40s, £50,000. So it can become really expensive, and then you've got the cost of defending it. So it's not to scare people, but the reality is that's what I'm seeing a lot of at the moment, especially when we've been forced to homework and people aren't able to support their staff in the same way. It's just being mindful of the environment and of the risks, because the financial risk is definitely there. It also could lead to other claims. So unfair dismissal, if you don't make an adjustment and then you have to sack someone because they can't do their job, then it could be an unfair dismissal, even if it's not discriminatory. So again, it's just linking those things and making sure that you're not pushing yourself into the boundaries of unfair dismissal, where again, individuals can claim over a year's salary. And the same for constructive dismissal. So this is where they might resign because you failed to make an adjustment, or because of any other type of discrimination. They could resign in response to that. And what that means is the individual could say that the actual discrimination itself is a fundamental breach of contract, resigning, claiming unfair dismissal, but constructive unfair because they've been forced to resign. So enough of the scary stuff. Hopefully that's been helpful. If anything does happen of that nature, you do get a bit of notice, because employees have to go to ACAS first. So they have 3 months less 1 day. Don't ask why it's less 1 day, but it is, from when the refusal occurred, or the last act of discrimination. But for the purposes of refusing to make reasonable adjustments or failing to make them, it's not from when they requested it, it's from when the refusal was communicated to them. So they have 3 months to make a claim, but they have to approach ACAS first. So you will know as a business before it goes to tribunal, and you'll have the opportunity to try and settle it. And that's really where I would always encourage people to have those open conversations and assess that risk. Because if the risk is, if actually it was a reasonable adjustment, if it was a reasonable adjustment and you've unreasonably refused it, it might be better option to settle. But actually, if they didn't have a disability, or it wasn't unreasonable, then it might be one to defend. So it really does depend on obviously the circumstances, but it's something to bear in mind, that you've got that bit of leeway, even if things do go wrong. So little bit how I can help. So we obviously do help people with HR stuff anyway, on a day-to-day, managing these types of processes, understanding what's reasonable, supporting approaching occupational health, the type of questions you want to ask. And we also provide support for individuals as well. So if anyone's feeling that they're in this personal situation where they need adjustments, we can advise individuals. And we have a free helpline, and which is on the next slide, I think. I'll come on to, and we also have some free bulletins, which anybody who is trying to keep up to date with what the hell is going on with coronavirus, or any updates regarding employment law, we just send those out as bulletins. So if you want me to pop you on there, just let me know, and I can arrange that for you. We also have our own wellbeing platform, so if anyone would like some free access to some champion training, we've got loads of initiatives and all sorts of stuff on there. I'm not going to talk about it for very long, but essentially if anyone wants any access to that, just email me, and I can give you a couple of days free access for you to take a look if it's something that you're interested in. And I've also popped a link to YouTube, because I've got loads of videos of different areas of law, not just disability, but race discrimination, sex discrimination, and redundancy, and all sorts of other stuff. So if you want some bite-sized, like under 5-minute videos on key areas of HR or employment law or mental health, I've got loads of stuff on there, and I've also got the free helplines on the screen. So I think that's enough from me. Have we got any questions?
We do indeed. We're pleased to know. So the first question, and I'll ask these succinctly in the order that they came. Is blindness automatic? So is blindness automatically a disability?
It's not automatically a disability. Only the 3 that I mentioned are, but I can't see how it wouldn't meet the test. So it's not automatic in the sense that it doesn't fall within the it doesn't fall within the automatic reasons, but I can't see how it wouldn't fall within the definition. So I would automatically assume yes, it does meet the definition.
Perfect. Next question is, hi, you may cover this in the question. I'd like to ask the question now. No need to answer. All right. If there are employees who have specific physical reasonable adjustments in place in the office, but now they are working from home because of COVID, are employers supposed to make the same reasonable adjustments in their home?
Yes and no, depends. So it depends what the reasonable adjustment was for. Now, if they've already got, say for example, it was a chair, but they've already got that chair at home, you don't necessarily need to. So the best way to approach it is to do a DSE assessment virtually with them and assess whether or not, first of all, they've got everything that they need physically, and secondly, whether or not they still need those adjustments. So it's more of a conversation around, actually, do they need it to that workspace at home? It may be because they're at home, they've already put their own adjustments in place. So it's just a question to ask, really. And it's just a bit of due diligence if people change a workspace, whether it's moving offices, moving desks, moving to home working. Always just reevaluate that and assess whether they still need them.
Perfect. Try to type some of the answers in. What adjustment can you make for someone with dyslexia?
So there's a couple of different types of adjustments actually, and I've done quite a few cases on this area. There's a lot of things like software that can, I think it's like speech to, I don't know what you call it now, touch type or touch to speak, but essentially it's where you can speak and it types for you and it spells it correctly. There's also a type of screen that you can put on because dyslexic people often find it easier to read with coloured screens or coloured lenses. So there's different types of things. I found that it very much depends on the individual, and some dyslexic individuals don't really need a lot of support and others really need a lot. So again, dyslexia is one of those that actually doesn't always meet the definition. So it does depend on their impact. So you've got the impairment, but what's the impact on their ability to do the job? And then if you can go to get a specialist, someone who specialises in neurodiverse employees and reasonable adjustments, they will be able to tell you what can help. But there's loads of stuff out there that you can buy that's quite cost effective. But it might even be that they want someone to just proofread their work, or they don't want to be, I don't know whether they're getting disciplined for typos, that type of thing. An adjustment might be to not discipline them for that. So there's quite a lot of different things that you can consider, but hopefully those help. There's an organisation called Creased Puddle. I'll send a link actually to some stuff that they do, but they specialise in supporting neurodiverse employees in the workplace. And they do lots of bespoke work. So they've got some stuff about reasonable adjustments for people who are neurodiverse, which that falls into that category. So I'll send a link out for that, which might help with a few more ideas.
No, perfect. Thank you. You're right. Yeah, we'll share that with the slides if anyone wants a copy of that. Please do let me know. If you rent an office space in a communal building, is it the company's responsibility or the landlord's responsibilities for physical adjustments such as a lift?
If the lift, I see what you mean. So it's not, well, it's a combination of the two. So if the physical barrier to the employee getting into the workplace, there is still an obligation on the employer. So the employer should speak to the landlord about getting that put in place, but physically putting it in place would be the landlord because it's their building. So it does depend on the lease and what the arrangements are, which obviously I'm not a property lawyer, but essentially the obligation to the employee, actually, it's their obligation. But there is actually which we haven't touched on today because I don't actually deal with this area, but if it's going into a public space, organisations who aren't employers, such as the landlord, also have a public duty. So there are other requirements, they are within the Equality Act, but not in a non-employee-employer relationship. So they would ordinarily have that obligation anyway. So if the employer spoke to them, they would have to deal with it. So if that makes sense. So that's why I'm saying it's both. So the employer has the obligation to the employee as an employee-employer relationship. But if it's access to a public space, then the landlord would also have an obligation.
Okay.
But
yeah, I think that answers it.
Under a different bit of the Equality Act, that's all.
Yeah, I think that answers the question nicely, thank you. Someone asked to explain the last straw doctrine. In the event of multiple breaches of policy and discriminations over time, the employee has raised concerns with management and HR, but has been constantly ignored.
Yeah, so the last straw doctrine is actually nothing to do with discrimination, but I can explain it. It's part of the constructive dismissal argument I was talking about before. So when there's a constructive dismissal, what you can do is either resign in response to a fundamental breach, a single act, one fundamental breach, or you can resign in response to a series of non-fundamental or a mixture of fundamental and non-fundamental, basically a series of acts over a period of time that have collectively damaged the working relationship to a point that there is a last straw. So it might be, I don't know, there is a failure to make adjustments at the end or something like that, that the employee resigns in response to that. And that's the final straw that they resign in response to. But all of the other acts are relevant for the purposes of the constructive dismissal claim. So that's how that works. It's taking all of it together. And actually, it comes up a lot with discrimination, because often there'll be a bit of a process of rejecting refusals and, you know, I don't know whether it's disciplinary processes that they have to go through. And over time, that damages the working relationship. And then there's the final straw is this is like, actually, I'm done now, I'm off. So that ends up being the situation where they'll then pursue a constructive dismissal claim if they've been employed more than 2 years. I think that's answered the question.
Yeah, I think so. What's the type of evidence which would support confirmation of meeting the legal test of disability?
Say that again. What's the
Sorry.
confirmation?
What is the type of evidence which would support confirmation of meeting the legal test of disability?
Okay, so from an individual's perspective, first of all, you don't need a medical diagnosis. It's about understanding what the impact is. So you don't need any physical evidence per se. It's about what you understand, what your knowledge is as an employer. So if it's an employee to try and prove they have a disability, the best thing to do is to say, this is the condition that I have, this is how it impacts me on a daily basis, and I've suffered for more than 12 months, to basically illustrate that you meet that definition. So I think they were asking it from an employee's perspective, but
Yeah, I think I'll take that to be. Next one is next couple of comments thanking you for the advocacy for Occ Health, which is great, and general comments around the session itself. The next question is, what is meant by substantial disadvantage?
So a substantial disadvantage is something that is more than minor or trivial. So it's essentially, I'll give you an example. So if it's that if I've got like so I have anxiety, so my substantial disadvantage is I can't concentrate, I can't sleep, I'm very distracted. There's lots of different things. When taken together, there's a substantial disadvantage on me being able to do my day-to-day tasks. So I have to put things in place to alleviate that. So there's quite a lot of case law around what is minor or trivial. But essentially, it's often not just one thing. There's more than one. But obviously, it depends, because if there's just one thing, like I can't get up the stairs, that is obviously substantial. So it's very fact specific. But the guidance that I'm sending out has a whole, well, it's about 3 pages on what is substantial and what is minor or trivial. It's quite a big area of case law. So when I send the slides out, when you click through the definition of disability, it's all on there, and there's quite a lot of information that you can then look, and you're presumably asking because you've got a situation that's relevant, so you can have a look and obviously assess it. But if you look at that and you actually think, do you know what, still don't get it, contact me directly. I'll be happy to talk through a specific example if that helps.
Amazing. Next question is, what about menopause?
It could be. I haven't actually seen it as a disability yet. Again, you don't actually need a diagnosis of a condition. So all you would need to show is that it meets the definition. If it has a substantial impact lasting more than 12 months, it certainly could. I know many women who have been in situations where actually it's caused things like anxiety, depression, unable to sleep, unable to focus, and actually all of those things could amount to a disability. So it's certainly something to consider. But it depends on the impact, doesn't it? So the fact they have menopause doesn't mean it's a disability. It's what is the impact of the menopause on that individual to do their job or do their daily activities and function effectively.
Perfect. Yeah, I think you're right. It's case by case, isn't it, as you say?
Yeah. So
And the last. Sorry.
It's a bit like saying, oh, well, what about depression? Well, for depression, for some people, it has a substantial and adverse effect, but for other people is manageable and it doesn't impact on their daily activities. So it really does depend on, it's not the condition, it's the impact. Always think about the impact, not the diagnosis.
Amazing. And the last few are just around comments around the session itself. So if there are no other questions, then I thank you all for your time today and tonight even, and taking the time to listen to what we've got to say. For those of you that do require a certificate or would like copies of the slides, please do let me know and I will share those with everybody. Hopefully you've seen our other webinars. The next one is around identifying symptoms of burnout and compassion fatigue, which is next Wednesday. So please do check that out, and we've got a range of other webinars on our website as well that we're constantly updating. So yeah, check that out, head to our website and see what other events and webinars we have running. But I'll bring this to a close. Thank you so much for coming and hope you've enjoyed it. Thanks a lot.
Awesome. Thanks, guys. Bye.